Okay, so this lecture relates to overriding interests and then the ability to overreach certain of those interests. So we're very much focusing on people that have an interest in the land and then are in occupation when we're thinking about overriding interests. And then usually where there's a beneficial interest that's at stake, we can find a way to take them out by payment of the monies in the property over to two trustees, therefore overreaching them. So that's what this lecture is going to look at, the principle by which their occupation allows them to override future purchasers' interests, but then that their overriding interest can be overreached. So it becomes like a kind of game of who's got the best hand, in a way, of kind of someone going, ta-da, you can't buy this property, or you can't repossess this property because I have an overriding interest, and them going, well, actually, hang on a minute, we can trump that by overreaching you. So it's effectively ramping up the game, if you were to look at it that way. So what I want to do is make sure that we're comfortable with all the ways that these people should have appeared on the register first, and then consider whether there is this crack in the mirror that would allow them to slip through, and how then they may have an interest that would override someone else coming onto the land, even though they could have registered potentially, that there still is a way that they're protected. We'll look at what actual occupation means. So what is it that we're looking for as evidence of their actual occupation? How much occupation is needed? Do they have to kind of permanently reside there, etc.? And then we'll look at how we can take away that interest in some way. So although they have an interest that overrides, how do we trump that? And the way that we trump that, usually where there's a beneficial interest anyway, we can overreach it. So that's what this lecture is focusing on. So I just want to take you back to the example that we've been using in the lectures so far. So we had Ali with the ownership of the property as the registered freeholder, making her the fee simple absolute and possession holder. We recognised that that was legal estate under section 1A of the Law of Property Act 1925, and the need there for a deed under section 52. Where we're at now with registration is that final box. So recognition of what it was the first box, law and equity being the second box, the need for documentation being the third box, and the fourth box being the registration requirement to affix and attach it to the land. So in order for Ali to show the world at large that she exists as the true owner or the freeholder, the fee simple absolute and possession holder, the proprietor, all of those words, she would have to have entered a registrable disposition under section 27 and appear on the proprietorship aspect of the register. That would have to be done. Brenda's leasehold, bearing in mind that we already knew the information that was required to evidence how we protect that. It was a 10-year tenancy, so therefore it's always going to be legal under section 11B, but we know with anything over 3 years that we would require then a deed as well. And then because again it's over 10 years, we have it enterable as a registrable disposition under section 27 of the Land Registration Act 2002. So mandating that someone like Brenda has to tell the world at large that they exist by entry on the register. So I'm going to leave Yvonne out of this for a moment, because Yvonne is the person that ultimately is going to be at the core of a lecture like this, a beneficial interest under a trust. But we'll look at the other ones as being able to appear on the register. Karen has an easement. We looked at whether it was capable of being legal, if it was like a fee simple absolute in possession or a term of years absolute. So is it freely given to Karen and anyone else, or is it fixed in time? And then it could be legal under section 12A, requiring a deed, and then becoming a registrable disposition under section 27 of the Land Registration Act 2002. Otherwise, if it had been equitable, so if it was only for Karen, or if it was vague in nature, it would be an equitable easement subject to contract, and Karen could protect that easement by entry of a notice under section 32 of the Land Registration Act 2002, with again us knowing that that would be what she would have to do in order to tell the world at large that she had that form of attachment and a fixation to the land. Failure to do so will mean that it becomes a personal matter that isn't evidenced sufficiently in land law. Dillon's restrictive covenant, so the promise not to use the place as a business, we knew wasn't capable of being legal under section 1.1, or wasn't capable of being legal interest under section 1.2, could only be equitable under section 1.3. Therefore, the only document that could be put on that would be a contract. And again, for those forms of equitable interests, we're usually seeing a notice under section 32 of the Land Registration Act 2002. The bank's mortgage being legal under section 12C, again, legal interest requiring a deed, and the nature of it requiring that it appear on the register. It's a registrable disposition under section 27 of the Land Registration Act 2002. Ali's landlord's right of entry, again, was one of the ones listed as a legal interest under section 12E, requires documentation by deed, and again is one of those things that as a legal interest has to appear and should be protected on the register for the world at large to see. Ultimately then, where we're headed today is to think about Yvonne. Yvonne has a beneficial interest under a trust. We already know that it can only be equitable under section 1.3, and we already know that normally we would require a contract in such a situation, but that here already we have a form of exemption or exception because these situations are usually familial or domestic or relational in some way where there's a loving relationship. And it's not expected that parties like that will have written down or evidenced in writing their conversations with each other about how they hold property. So under section 53(1)(b) of the Law of Property Act 1952, we can see that there is an exception to the need for writing. And then when it comes to registration, we can again see that there will be exceptions made. Yvonne is one of the few people who can't enter a notice. So she can't enter a notice as having an equitable interest. Section 33 of the Land Registration Act 2002 says that she cannot because she just has a beneficial interest under a trust. And she's not a spouse. So therefore, Yvonne's only protective mechanism would be to enter a restriction through section 43 of the Land Registration Act 2002. Yvonne could enter a restriction telling the world at large that she exists. However, again, in a family or domestic situation, that's highly unlikely to have happened. And that's where there's this crack in the mirror where we have to be seen to protect people who don't know, or it's cumbersome for us to expect that they would have behaved that way. So we'll look again at how Yvonne might have protected herself more clearly through a restriction when we're looking at overreaching. But at the moment, we know that it's a protective mechanism where she could have told the world at large. However, she's very unlikely to have done so unless she had some strong legal advice. And in that case, we're thinking about whether she might have an overriding interest because we know she lives in the property. So that's where we're headed today. We're going to look at this crack in the mirror, the fact that this person who's living there may still be able to hamper or restrict anybody coming along to take the land from over them. So we know that overriding interests are that crack in the mirror. They are an exception to the fact that a purchaser should usually not be concerned if they don't see something on the register. So those things that I talked to you about a moment ago, like those easements and covenants, etc., that have to appear really on the register in order to attach and affix that person to the land. We can then, with full confidence, pass land over to a purchaser with the knowledge that if those claims haven't been made on the land, that that person's interest is personal and not proprietary in nature. However, with overriding interests, it may either not be possible for them to register it, or there will be no requirement for them to register it. And therefore, there is no kind of way for them, there's no notice requirement, there's no ability for them to tell the world at large that they exist. So we're thinking about that crack in the mirror and the fact that they will therefore override anybody else coming along to the land, and what that then means. We know that that's provided for first registration under Schedule 1, subsequent registrations then under Schedule 3. So if you're dealing with land that has previously not been registered, you would look at Schedule 1. If you're looking at registered land, which is what we're going to do, we're looking at Schedule 3. So these people aren't on the register at all, but they will bind a future purchaser. So it's incredibly important to find out about them. And that's where that form comes in that we looked at in the previous lecture, that it's not really up to the purchaser to be able to articulate and identify every party. So one way that Law Society and Conveyancing have dealt with that is to send this form out to the seller for them to clearly articulate who belongs to the land, who has a vested interest in the land, and will that person be leaving at the point of sale. And that's a very important factor that we're considering. An assurance from the seller to the purchaser that the land is being sold of that free of that party and their interest. So we've looked at this. We've got the two schedules there, Schedule 1 for the first registration, Schedule 3 for future registrations. So dealing with registered land, we'll look very heavily at Schedule 3. So we know, again, through notice, that somebody with a lease between 3 and 7 years could have protected themselves on the register. However, Section 33 of the Land Registration Act says that if it fell below 3 years, they couldn't. Irrespective of those 3 to 7 and under 3 situations on notices, if the lease fell below 7 years, the person would have an overriding interest anyway. So that leaseholder is somebody that can fetter and restrict a future purchaser coming along to land. And that's why they are articulated on the form. That's why they are identified on the form. Similarly, the interests of a person in actual occupation of the land. So that's somebody who has an interest in land and is occupying it. There are exceptions to that, and that's where we're going to go today. That's some of the stuff we're going to look at in this lecture. Legal easements and profit de prendre, so those situations where people have the ability to exercise a right of way or go onto land and take something from it, like wood or apples, etc. Those are factors that could become overriding interests, again with exceptions. And I think it would be best for us to look at those more clearly when we get to easements to make sense of the various ways that you can register an easement and then what then happens to it as an overriding interest. The other miscellaneous rights situation you've got there would be things like mines, minerals, manors, everything beginning with M, it seems. So what I'm going to do now is I'm going to take you to the Land Registration Act Schedule 3 for us to look at that and start to make some sense of it together. So Schedule 3 is quite clear in terms of it sets out each of these aspects that I've just related to you. You've got the leasehold not exceeding 7 years from the date of grant. We've got interests of person in actual occupation with the exceptions listed, and we're going to look at those together in a moment. We have easements and profit de prendre with the exceptions again, which are very similar to the exceptions for people in actual occupation. So was it obvious? Did the person know about it? And then we've got mines and minerals, as I said, a franchise, a manorial right, a right reserved to the Crown, a right in respect of an embankment or sea, a tithe, a church. So you've got some very old-fashioned, archaic ones that would be deemed to be overriding interests too. But the main ones, obviously, for us as looking at domestic registered land transactions would be these shorter term leases under 7 years, someone in actual occupation, and somebody with an easement. Those will be the focus of this module. As I say, today our highlight mostly is here. Our highlight really is this person who is in actual occupation and the exceptions. We need to drill into that with a little bit more depth. So, the exceptions being, so we've got an interest, this is the overriding interest. The interest is overriding if at the time of the disposition, so at the time of the transfer, there is a person who has an interest and is in actual occupation. The exceptions being these moments of inquiry. So the exceptions being, was it obvious on careful inspection of the land, and did they have knowledge of it? So if it was obvious on careful inspection of the land and they had knowledge of it, they will be bound by that person who is in actual occupation, because they will be deemed to have seen it and or known about it, and therefore they could be bound. So that's why that form matters. That's why that form is asking the question, so that the purchaser then finds out what the answer is. The seller is telling them who this person is, and then they will have knowledge of them and they will be bound by them. So we have to figure out, when we're looking at the land, is it obvious that someone else is there? And then we'll send out the form, we'll ask the questions. However, a lot of this would then hinge around the fact that we would have a form, we would have a normal conveyance where somebody is sending out a form to a seller, a purchaser is buying, etc. But that's not how every transaction happens where there is a disposition of land. And a lot of the case law surrounding this is actually about a repossession. So the repossession will be from the bank, and the bank are wanting to take the property back. They don't have a nice form to send out to anyone. The person that they would send the form to is the person who is in default and they're repossessing. So then they're going to end up with encumbered land. They're going to end up with land where there may be somebody on it, even if they know about them, they may not have a choice because they haven't been able to deal with it in any other way. They just want to take land back. And then it becomes about finding out the minutiae of, was that person in actual occupation and did they have an interest? Because they haven't had any dandy form to send out to ask anyone this information. They're just wanting to repossess a house, but it's got someone else in it. So the notice requirement nowadays is generally dealt with through that form. The inquiry aspect and the inspection aspect are clear and they're stated in Schedule 3. If the person with the interest was asked before the disposition occurred and she or he failed to disclose their interest when they could reasonably have been expected to do so. So this is the situation where someone is asked, and if they don't disclose it, then their interest will not be valid. Also, inspection. If the person's occupation would not have been obvious on a reasonably careful inspection of the land at the time of the disposition, and the person to whom the disposition is made did not have actual knowledge of the interest at the time. So you see these cases where people have either tried to hide the fact that somebody's been on the land or not made the correct inquiries. So, for example, in Hodgson and Marks, Mrs. Hodgson, she sold the house to the person who was her lodger, Mr. Evans, wanting to remain the kind of beneficiary. So he would have title to the house and she would be a beneficiary. And they carried on living together there. He was the fee simple absolute and possession holder, so he had title to the house, and he sold the house to Mr. and Mrs. Marks. The Marks had come to view the property, and whenever they were on the way towards the property, they saw Mrs. Hodgson as well. They didn't ask who she was. They didn't ask if she had any interest in the house. They just assumed that she was his wife or his girlfriend. And therefore, the judge in the first instance found that the Marks were not at fault in that situation because there wasn't any actual visible representation of her. However, on appeal, they viewed that Hodgson was in actual occupation, and it was irrelevant that what the Marks thought. There was no requirement that the occupation itself needed to be completely obvious, that it was in their interest to find that information out. And that's where the importance of that form comes in asking the seller those questions and them having to be honest about it. Then there's an amount of notice being given. So some of these cases, you can see the 1971 nature of these cases are such that we're dealing with situations where people are now, through the conveyancing processes, not having to worry about this. But we're looking at these older cases to be of help when we're thinking about banks' repossessions or other situations. So in terms then of what actual occupation would mean, we're looking at somebody's physical manifestation and evidence of their presence in some way. In Williams and Glynn against Boland, we have a situation where we can see that you've got bank versus in a lot of these cases. So these are meaning that there are repossession cases. In Williams and Glynn, we have the bank repossessing against Mr. Boland, who was the fee simple absolute in possession. with the wife being a beneficial interest under a trust. So the wife being that party that we have been talking about, that the Edna in the problem question that we've been dealing with in seminars together. This party who doesn't appear on the legal title but has a beneficial interest under a trust. So the bank go to repossess against Mr. Boland, who's the fee simple absolute possession holder, for default, and Mrs. Boland tries to hold the bank off by dint of her occupation in combination with her interest. So she has a beneficial interest in the property and she lives there. And there was obviously dealing with the 1980, very, very early 1980s, where there was a consideration as to the wife's place in terms of how viable it was that her separate occupation counted against his. And the courts quite refreshingly stated that her occupation was factual. She was in residence there, she did have an interest in the property, and that her occupation was a separate interest and separate entity to that of her husband's, and she could hold off the bank in that situation. Therefore, being literally an overriding interest, her interest overrode that of the banks when it came to the repossession. Them, as a subsequent party to this, coming to it at a later stage, could not take the property over her. Okay, so she overrode the bank in that situation. In Hodgson and Marks, again, there was this element of occupation by Mrs. Hodgson. She had continued to live there. She didn't need to have her name on the door or very clear ladies' garments lying around. That her actual occupation hinged on the fact that she had a mere physical presence there. She resided there, and that sufficed. So a very clear indication to other people that there was some presence of hers there. Abbey National Building Society, and can we see again a repossession? So we see a repossession in this situation over a son and mother relationship. The son being the one in default, the mother having partially invested in the property. And the mother's argument was that it was a second property actually that was being repossessed, and it was repossessed quite quickly. But her argument was that she was in actual occupation, whereas the court ruled that she wasn't even in the country at the time because she hadn't quite managed to move in. Her son and her husband had moved some items into the property, but she was in a different country. And the court ruled in that case that it wasn't sufficient. There wasn't a sufficient degree of permanence and occupation and continuous occupation in order for her to establish that her interest overrode the bank who wanted to repossess in that case. So there has to be some essence of in the two cases we looked at already, Boland and Hodgson, we've looked at people who live there. There isn't a notion that just kind of moving some of your stuff in there but not being physically there yourself is enough. We then have the potential for that to be abused in the case of Chakar and Chakar, which is a truly awful case, where the wife was actually in hospital giving birth to their child when the husband tries to sell the family home, or sells the family home, hiding all of her things. Uh, the wife then having to claim an overriding interest against the new purchasers, stating her beneficial interests coupled with her actual occupation. The argument then arising around the fact that he'd hidden all her stuff, that it wasn't obvious on inspection that she existed, he'd lied about her, blah blah blah, and said he was single. So thinking about a new purchaser coming along to that situation, having done nothing wrong, it's not obvious on inspection, he's not explained about anybody else, how would that be dealt with? And the courts viewed that in that situation, a temporary absence such in that way didn't suffice, and that she did have an overriding interest, that again her residency there, whether there had been some form of subterfuge and hiding of her things, didn't suffice to remove her interest and occupation from the property on the whole, especially as a family home, especially given why she was absent. So she was successful in that case. So we see some, unusual situations there where there may be some wrongdoing. Definitely Hodgson and Marks and Chakar, we see some wrongdoing by the parties who are trying to sell a property over the beneficiary, and how that's then resolved. With the two bank cases, we're dealing with repossession, so we're dealing with the fact that there would be no form to look at to see whether there is honesty and declaration as to whether this person exists. However, it's perfectly possible to walk in and see that their stuff and things are there. It's perfectly possible to have a cup of tea with them and know that they're there. It's perfectly possible to have a seller return a form telling you all about them, and then know that they are there, they exist, and that you want to take them out. You want to not be bound by them, and you still want to buy that property. So that's where a thing called overreaching steps in. Overreaching translates their interest to being about the property into being about money. So basically, it's the antithesis of everything we've spoken about so far, where I've told you that an action in land is about the in rem nature, it's about the thing, where all we're doing is trying to attach and affix the person to the thing. And in reality, unfortunately, this is one of the situations where that doesn't fully wash. That even if we do all this good stuff of saying that this person exists and we can attach and affix them, even if they have a restriction, it's possible to overreach them and take them out by the payment of money to two trustees. So we'll look at that together. Firstly, we'll think about this person who is in occupation. So this is usually somebody who is a person who is in actual occupation of the land because they have some form of relationship. The requirements are that there is an interest or a right in the land, so they're not just kind of a transient or somebody sleeping in a doorway, that they have an interest or a right in the land, that they have that actual occupation. Again, that it was obvious on inspection, and that element of inquiry has been met. It's not enough just for them to be there. It's not enough for them just to occupy. So if we're looking at a case like Strand Securities in Caswell, we have a tenant who tries to hold on to their security in the property by placing their daughter there in lieu of them. So they ask their daughter to reside at the property to evidence a form of occupation, and that did not wash with the courts. The courts said that you couldn't put somebody else in place of you, that the occupation had to be by the person who had the right in land. So we're looking for that person who's in occupation to have an interest in the land, to actually occupy it, and it be obvious, etc., and there be no subterfuge. So then how do we deal with them? We've started to talk about this a few times. I've been sowing the seed about this idea of how we deal with them. How, once we know that someone's there, do we take them out? And we'll look at that in a few different situations. We will look at that in more depth when we come to easements as well. So once we know about them, we can see them on the register, or we've asked the question and been told, how do we actually deal with them? How do we stop them overriding our interest in the land because we want to buy it? How do we, or we want to sell it? How do we deal with them? Well, the system of overreaching is allowed to take place. It involves the payment of money. The purchase money for the entire property would go to two trustees. It therefore is the translation of the interest in the land into money, which is what I've said all along we're not going to do, and we don't do, except for this one situation. So we're translating their beneficial interest in the land into financial interest, because the land can still be sold to a future purchaser. The money then has to be paid over to two trustees. This moves effectively the beneficial interest in the land from the land itself and the property, and puts it into their percentage of the proceeds of the sale, meaning that it's not the new purchaser's problem anymore. It's not their business. They've paid the money to two trustees and they take the land. If the beneficiary wants to deal with it or has a problem, they have to go to the two trustees and go to court and waste some of their money in paying to resolve this situation to get their share, but it doesn't become the new purchaser's problem. The purchaser takes completely freely of them, and that's allowed for under Section 2 and Section 27 of the Law of Property Act 1925 that we're going to look at together in a moment. And why? How are we allowed to do this? Well, effectively, we're allowed to do this under a provision of the LPA that no longer exists. So let's have a look at all this together. So, Section 2 allows for overreaching. Section 2 of the Law of Property Act conveyances overreaching certain equitable interests and powers. A conveyance to a purchaser of a legal estate in land shall overreach any equitable interest or power affecting that estate, whether or not there is notice. So you might know about them, but you can still overreach them, is effectively what that is saying. Okay, and then it sets out how you do it. So that says it can happen. Section 2 allows for it to happen, and Section 27 says how you do it. So how you do it is the purchaser will not be concerned with the trusts of the proceeds of the sale, because they're going to be paid to two or more trustees or to a trust corporation. The purchaser of the legal estate shall not be concerned with the trusts affecting the land, the net income of the land, the proceeds of the sale. Basically, they don't have to care about any of it. They want to buy the land, the person selling it wants to sell the land, and the sale is allowed to happen. They are allowed to be overreached under Section 2. How they overreach is through Section 27 by paying the whole purchase monies across to two or more trustees or a trust corporation. And effectively, the thing that allowed that to happen is no longer good law. The thing that allowed that to happen was Section 28 of the LPA, which referred to a trust as a trust for sale, which is now a trust of land under the Trusts of Land and Appointment of Trustees Act 1996. So we have the TOLATA, Trusts of Land and Appointment of Trustees Act 1996, coming into effect, taking out the trust for sale. It's no longer here. Look, it's no longer good law. Section 28 doesn't exist. But in calling it a trust of land, we have progress in terms of the terminology. However, we can tell that Section 2 and Section 27 have not been replaced. So the reference to it being a trust for sale is gone, but the mechanisms for still doing that exist. So that's quite an interesting point. Again, you are being asked to do a presentation on something interesting. I find that quite interesting, but there we go. So we can overreach by paying the money to two trustees. This moves their interest from being about the land into the money from the sale. The purchaser takes free of them, not interested in them at all, because they've paid the money across to two trustees because the trust was for sale. And then the only protective mechanism that could have worked, would have worked, should work is a restriction. And the key case in all of this is the Flegg case. So I'll explain the Flegg case to you, and then we can have a look at other examples whenever we are together in class. The Flegg case is quite interesting because we have the Fleggs and the Maxwell Browns. So the Flegg case is in relation to a daughter and her parents. And we have sorry, bear with me 1 second. Just trying to find my note that I have written to myself to explain how to make this come to life a little bit more. I usually do a role play, but I can't do a role play. Anyway, we have the Maxwell Browns buying a house, and we have her parents, the Fleggs, helping them to buy the house. So we have the Fleggs contributing to the purchase price. However, the Maxwell Browns are the one with legal title. Okay, so found my notes, sorry, right. So, if you think about the fee simple, absolute and possession, the FSAP at the top, and we look at legal title, you know that we have looked at for that person so far. So we're looking for them every time we see a problem question. On the legal title, you would see Mr. and Mrs. Maxwell Brown. Up to you if you want to write that down, and we will do it again in class together. So we've got the Maxwell Browns in the eyes of the law as the holders of the legal title. However, the Fleggs are the ones that have helped contribute half of the purchase price for this property. So down in equity, beneficial interest under a trust, section 1.3, should have a piece of paper, we have got the Fleggs. So Maxwell Browns, FSAP, section 1.1a, would need a deed, yada yada. And then we've got beneficial interests, the Fleggs, section 1.3, contract, ideally. We'll then think about whether the Maxwell Browns default and seek possession of the property. So again, we can see there's a bank at stake here. We can see that this is a repossession, and we have a repossession of the property from the Maxwell Browns who have been defaulting. And the Fleggs saying that they have a beneficial interest because they have contributed to the purchase price, and it's an overriding interest. So they have a beneficial interest, and it's an overriding interest because they were also living there and they were in actual occupation when the mortgage was taken out. However, if you think about what I've said about the legal title, we had the payment of the mortgage monies to two people. Payment of the mortgage monies, the capital money that is at risk here, has been made to two trustees. And effectively, if the property is going to be sold and any profit is taken from it, that would also go to the Maxwell Browns. And the Fleggs are going to have to fight the Maxwell Browns, not the Building Society, because they've been overreached. The mortgage money was paid to two trustees. Any sale of the property, if there was any gain from that, the money would go to two trustees. So effectively, the Fleggs would be overreached. We'll work through that together in class. But what I need you to draw down from this is that the only way a beneficiary can truly protect themselves, because the Maxwell Browns could be off in Honolulu drinking cocktails with any sale proceeds, or in jail, and the Fleggs will never see it. The only method you have of protection for yourself as a beneficiary is to create a very specific restriction under Section 43, that in the event of any sale or any release of funds against the property, the payment has to be made to a trust corporation or a specific set of trustees. That payment to the two people that are liable to do you the most harm would be inappropriate. So your restriction under Section 43 to protect you fully would have to be very well worded. Otherwise, you would be subject to just being overreached by payment to anybody's, really. So we looked at this before. You could require that the payment be made to two trustees that you trust. You're revealing that your beneficial interest exists. Someone's going to know that you need to be overreached, but your overreaching will happen by payment to two people that you want it to happen to, and not two people who could take advantage of you. We've looked at the fact that the bank could require consent, but that's not the exact restriction that we're looking for. The sort of restriction we're looking for would be that we would need something authorised by a trust corporation, we would need it authorised by an order of court, some form of wording that restricts the capacity within which you can be overreached would be necessary. And we'll look at that in a lot more detail when we're in seminar together. So thank you. What I wanted to do is recap registered land, look at this fact that there's a crack in the mirror and there's an interest situation overriding future people coming along to the land, such as new purchasers, such as banks repossessing. We've looked at what actual occupation means and looks like, and we looked at the fact that even if you do know about them, there are times that you can take them out by overreaching them by payment to two trustees. So then if you are the party who's more vulnerable, to stop that from happening to yourself, you're not going to be able to stop overreaching happening because it's enshrined in the LPA, but to protect yourself, you might want to enter a restriction that stipulates who those parties are. Who are those people who are going to get that money that you've been translated into out of the property? So thank you very much.